Bonjour, my name is Michel Struys. I'm a partner at Annulment Antitrust based in Paris and Brussels. Today I'm going to take you through some description of the Court of Justice and tell you more about litigation before the European courts. We'll first start with an overview. The main aim of the Court of Justice is to review the legality of the acts of the institutions of the European Union, control that the member states comply with their obligation under EU law, and finally interpret European Union law at the request of national courts, or eventually strike out European acts at the request of national courts. Most people ignore that, or some people ignore that the Court of Justice is a generic name which covers three courts: the Court of Justice itself, ECJ or CJEU nowadays, the General Court, which was known as the Court of First Instance, which was created in 1988, and the Civil Service Tribunal, which was created in 2004. Since its establishment, the Court of Justice rendered no less than 25,000 or about 25,000 judgments. Now, if you look at the General Court and the ECJ, they have common features. First, they have 27 judges for 27 member states. Unfortunately, the member states did not agree when the treaty was under revision to abandon the idea of having one judge per member state. Now, they also sit in chambers, chambers of 3, 5, 13, whereas if that's for the General Court, and sometimes the General Court sits in full court, which is extremely unusual. Sitting in full court means 27 judges. The Court of Justice will also sit in chamber of 3, 5, or full court in grand chambers of 15 judges. The major difference between the Court of Justice and the General Court resides in the fact that there are 8 Advocate Generals at the Court of Justice, while there is no Advocate General at the Court of First Instance or General Court. The role of the Advocate General is to prepare an opinion, intervene amicus curiae, advise the court as to the direction the court should follow. When you read opinions of Advocate General, they are very often much longer than judgments themselves, and depending on the personality of the Advocate General, you'll find the history of the case law, which should help the court, the judge sitting in the chamber, to make a final decision as to the orientation of a case. Now, most people would believe that antitrust must represent a significant proportion of judgment of cases dealt with by the European courts, which is not the case when you look at statistics. Only 4% of cases before the ECJ are actually competition cases in the period 2007 and 2011, and if you look at the General Court, the statistics are slightly better. I mean, the competition cases account for only 9%. What you can see is that actually IP cases represents the vast majority of cases, or not the majority cases, but the biggest percentage of cases before the General Court. Before the Court of Justice, the variety of cases is much broader. You would have social security cases, you would have IP cases, you would have also institutional cases. The range is very, very broad, pretty much compare to the range of cases the Court of the US Supreme Court could review. Now, when you look at the duration of proceeding, you will see that before the ECJ, reference on the preliminary ruling, and I will come back to that in a few minutes, would take on average 16 months to the judgment. when there is an urgent request for a preliminary ruling, the average could go down to 2.5 months. It's slightly longer because these cases are not prioritized when you are dealing with direct actions, and you'll see why these cases are not prioritized in a few minutes. And appeals of judgments rendered by the General Court takes on average 15 months to judgment. The situation is unfortunately not as good when you look at the General Court of the European Union. On average, if you take all cases, all judgments rendered in 2011, the average time is 2.5 years. When you look at competition cases, it's far more worrying. It's over 4 years, and it's not unusual, unfortunately, to have cases which last 5, 6 years, sometimes even a bit longer. Jurisdiction and actions. Now, parties. The first thing you have to wonder is who can bring a case before the court. Natural or legal persons may introduce an action before the court. They will have to demonstrate a direct and personal interest. Member states are privileged party, i.e., they don't need to demonstrate an interest to be able to seek the annulment of a community act, and they don't need to show an interest to even, and it's a procedure which is not well known, to take another member state to court. EU institutions, some are privileged, some are only semi-privileged, i.e. they will need to demonstrate that there is a connection between the act they are seeking the annulment and their prerogatives. One key feature is that one of the parties must be an institution of the EU. There is only one exception, and I mentioned this exception a few minutes ago, or a few seconds ago, that one member state can go against another member state before the European Court of Justice if that member state has failed to comply with its obligation. So it is not necessary to wait for the Commission to take a member state to the court for failing to comply with EU law. Another member state, but it happens very rarely, can take one of its counterpart to the court for failure to comply with EU law. Now, direct actions. There are three types of direct actions. You have the actions for annulment. You are seeking the annulment of a community act. There is the action for failure to act, and we'll see in a few seconds. This action exists to the extent that there is an obligation to act pending on an institution, and that institution fails to take measure, fails to adopt an act it is bound to take. An action for damages can be also brought against the institutions. Then you have the indirect actions, and I mentioned earlier the preliminary references. That's an indirect action, i.e. it's a direct dialogue between a national judge and the court. And the parties to the case before the Court of Justice are the parties to the case before the national court, but they don't argue before the case, they just submit their observations about the case, the questions which are referred by the national court. And then you have, of course, the judgment, the appeals on against judgments rendered by the General Court of the European Union. Now, the action for annulment. As I mentioned, the action for annulment may be brought by a member state. If they are brought by a member state, there is a privilege of jurisdiction. These actions will be reviewed by the European Court of Justice. And that is the reason why, there is no priority given to these cases, and it takes 20 months on average, rather than 16 months on a preliminary reference. Action may be brought by private parties, but they are heard by the General Court. There is no privilege of jurisdiction, but there is an upside. You can appeal any judgment rendered by the General Court. One thing to keep in mind is that actions must be brought within 2 months plus 10 days. You'll see only 2 months here. There is 10 days of the an historical remnants of the time where decision had to be faxed, and therefore there were several, extension of the 2 months differing from one member state to another, and it has been harmonized to 10 days now. The delay starts from the notification of the act to the applicant, from the day the applicant became aware of an act. Now, it's not simply awareness of the act, it's awareness of the content of the act. Now, if you know that an act has been adopted and you don't do anything to obtain, the substance, to be aware of the content, you may find yourself in a difficult situation. Because from the moment you know that an act has been adopted, that you will not be notified and it will not be published if you do nothing, and the institution from which the act emanates can demonstrate that you had awareness but did nothing, you may be actually foreclosed if you don't act very quickly. And finally, where an act needs to be published, the 2 months period, the 2 months and 10 days, will start at the time the act is published. Now, what kind of act can be attacked? Most importantly, the act must produce legal effects. So any intermediary step which does not produce legal effects will not be challengeable. You will have to wait until the act, the final act, is adopted. Preparatory acts, as a rule of thumb, cannot be attacked. Now, decision on confidentiality claims can be attacked. Antitrust decisions, decision rejecting complaints, ECMR decisions. On the contrary, decisions which cannot be attacked are the opening of a procedure or the issuing of a statement of objection, because there are preparatory acts in a proceeding which is going to lead to the adoption of a final decision. And only the final decision can be challenged. What are the type of acts which can be challenged? Individual acts, they can be challenged by a natural person or a legal person which is not a member state if they are addressed to the applicant. Otherwise, you will need to demonstrate the existence of a direct and individual interest. When it comes to legislative act, it's far more difficult, or regulatory act. You will also need to demonstrate a direct and individual concern, and that is often very difficult. When you have a regulation which basically is going to affect your position, this effect on you may not be sufficient because you are not individually affected. Individually means that you must be affected more than the rest of the citizens of your country or the rest of the citizens of the European Union. You must have a very special position which makes it obvious that you're going to be affected by the legislative and regulatory act. So you may wonder, what am I going to do if tomorrow I'm affected by a regulatory or legislative act, for example, by a directive, if I cannot attack the directive on the basis that this directive would be illegal? Well, you can then challenge the validity of this directive during a national proceeding, where, for example, you would have an act implementing the directive. In that situation, you will challenge before the national courts the validity of the Community Act, and the national court, if it believes that there is some ground to your claims, will refer the question of validity to the European Court of Justice. Now, in competition as well as in state aid cases, what you will notice is that usually you will show direct and individual concern if you have participated in the proceeding. And it's very clear in situation of merger control cases where the case law recognizes that companies which intervene in the market testing or submitted observations have a legitimate, direct and individual interest to seek the annulment of a clearance decision. Now, what are what are the grounds that you can raise? First ground is a lack of competence of the institution which adopted the act. So you need to check, the rules in the treaty which grant, competence for certain acts and check whether, these rules have been respected. The second one is an infringement of an essential procedural requirement, and in the Bolloré case, there was a very nice violation of the procedural requirement because the Commission, imposed a fine on Bolloré, though it had not issued a statement of objection against Bolloré, but only against one of its subsidiaries, and that was considered as a violation of an essential procedural requirement. Other grounds is an infringement of any treaty rules or any rule relating to its application. And there, you don't simply refer to the rules established by the treaty, for example, to the fundamental freedoms. You will also refer to general principle of laws or fundamental rights which have been recognized by the European Court of Justice. So you need to keep in mind that the judgment of the Court of Justice are as important as the treaty rules in relation to which they are, rendered. And finally, you can also raise a situation of misuse of powers. It's a situation where an institution has the power to take an act, but use that power for another purpose than the purpose for which that power was granted on that institution. Now, I will skip the case of Sony Impala, but you can get access to my slides and you'll see how the proceeding went on. Then, as I mentioned, the second and probably the most important procedure when it comes to the ECJ is the preliminary reference procedure, Article 267 of the Treaty of the TFEU. Now, if you look at Article 19 of the TFEU, it says that the function of the Court of Justice is to ensure in the interpretation of and the application of EU law, the treaty is respected. Now, national court under Article 267 of the treaty may refer questions to the Court of Justice, questions of interpretation or question of validity. It's may. There is no obligation if tomorrow you have a litigation before a national court and you raise a problem of interpretation of EU law, the national court may refuse to send the question. A very recent example of referral is the situation between Huawei and ZTE in a very important case regarding standard essential patents, where the national court, the Düsseldorf court, decided that the questions of law, of interpretation of EU law, pending or relating to the case was so important that it was necessary to refer and have the opinion of the Court of Justice. Now, if, however, we are dealing with Supreme Courts, i.e. courts against which you cannot appeal the judgment, these Supreme Court have the obligation to refer questions to the Court of Justice. Now, the French Conseil d'État developed a theory, which was the theory of the acte clair, where it decided not to refer cases back a few years ago to the Court of Justice, although there were questions of interpretation of EU law raised, because the Conseil d'État was claiming that, the rules, the provisions were clear, and it didn't need, although it was challenged, it didn't need the interpretation of the Court of Justice. Now, things to keep in mind is that the ECJ will never rule on national law. It is true sometimes that when you read the judgment, the judgments which are, or the questions which are referred to the Court of Justice give the impression that the Court of Justice gives a judgment or renders a judgment against the member states. It's not always very clear in the way it's drafted, but technically speaking, What the court is doing is only interpreting the EU law. No, there is no appeal on, with regard to the premium proceeding. There is no appeal, i.e. if you are not happy about the outcome of the interpretation of the Court of Justice or about its finding as to the validity of a Community Act, you cannot appeal that decision before another body or before another court, because there is no other court. What happens sometimes is that a national court refers a question to Court of Justice and gets a response from the Court of Justice, and the national court is sometimes unhappy and may ask again questions in a slightly different way in order to see whether it's going to get the same response, or to complement, to obtain a complement to the responses provided by the ECJ. Who is formulating the questions? The national judges, but in my experience, the parties are very often suggesting some wording to the national judges to make sure that the questions, the answers which will be provided by the Court of Justice will accurately address the problem. Now, also in my experience, sometimes the Court of Justice doesn't like the questions because the judges think that the questions do not make sense. In such a situation, the court will not hesitate to reformulate the questions which are addressed by the national courts in such a way that it will give a useful response to the national court. Unfortunately, sometimes this attempt to reformulate is vain, and actually the national judge gets frustrated because he gets an answer to a question he never asked. The judgment made by the Court of Justice, I mean, although they are, normally they are linked to the case, they will create some kind of, they will be the case law, they will have some res judicata on other cases. And if another national judge bumps into the same kind of situation, normally he should apply the ruling of the Court of Justice, but he can himself ask the same question to the Court of Justice. Now, either the Court of Justice reconsiders the question or he sends back the same answer. Now, it may well be the case that you have a case before a national court, and the national court, doesn't want to refer questions to the Court of Justice. And that's one thing is clear, is that a national court cannot reach a conclusion which runs counter to a decision adopted by the Commission. Often, in order to avoid the risk, the national court will suspend the proceeding pending the Commission's decision. In some cases, however, national courts will not accept to stay the proceeding, and they will continue in parallel with the Commission. They may ask for the Commission's assistance in antitrust cases, or they can decide to refer the case to the Court of Justice. In my experience, national courts are extremely reluctant to ask for the opinion of the Commission. They much prefer referring questions to the Court of Justice, and there is a very simple reason for this. The very simple reason for this is that judges don't like to talk to non-judges, and the Commission is not a jurisdiction.